Firstly, if you close your statement, I believe you said the court had it, Congress had it wrong and the court had it right. Is that what did I hear it wrong, or did you say it wrong?
If I misspoke, I definitely mean that Congress had it absolutely right and the Supreme Court had it wrong.
I thought that's what it was. Yeah, Congress finally got it right.
And it got it right on multiple times over multiple decades under different administrations.
Right after the Holder case, Texas had a photo ID law. Ms. A, do you know what happened with the attack on that law and what the Supreme Court, what the courts ruled in those photo ID?
I know it quite well because I'm part of the team and among many members who have been litigating that case now for 7 or 8 years. So we have to step back and also remember that the Texas photo ID law, which has been recognized as the strictest in the nation at one time, was adopted in the context of a legislature that had also adopted racially discriminatory voting plans that had been found to be intentionally discriminatory for the State House and for Congress. That same body, post-2010, adopted a strict photo ID law, and it was blocked by Section 5 because the record then, as the record came to show after trial and after several appeals, prohibited up to 600,000 registered Texas voters and up to 1 million eligible voters to vote. This was a law that was crafted to allow people with handgun licenses disproportionately held by white voters to vote. But student IDs, tribal IDs, Native American tribal IDs, federal and state employee IDs were carved out of that law so that people could not participate in the political process. We went to trial in 2014, and the court found that the law violated the results test of Section 2 and also violated various provisions of the U.S. Constitution. That case went up, and an en banc court of the Fifth Circuit affirmed that that law, and by en banc I mean the full panel of the Fifth Circuit, affirmed that that law had discriminatory results. And our position is that and subsequently remanded the case. There was an interim remedy where, frankly, Texas had to be forced to come up with a remedy for voting for its discriminatory photo ID law. They had to be forced after they were told by Section 5, after people provided testimony before them that the law was discriminatory. They had to be forced into an interim remedy. That interim remedy was subsequently upheld by another 3-judge panel of the Fifth Circuit. We, frankly, our position is that that decision did not disturb the intent ruling.
And was that remedy possibly the law that Mr. Hawkins said was passed?
Yeah, and that's
But was that after an election had taken place?
That was after many elections had taken place.
What remedy was available to those voters who were affected by a law that the court said was discriminatory?
Absolutely not. Millions, if not hundreds of thousands of votes were lost under.
It's not a rodeo, but it's the cattle are out of the barn and they've gone. Nothing you can do at that point.
They're over. Because people have been elected under, and that was the genius behind Section 5, that Congress understood that elections would take place. And we need to block harm before elections take place, before the cancer of racial discrimination takes root, before people get the benefit of discrimination, and the victims of discrimination have to then race into court at the cost of hundreds of thousands, if not millions of dollars, to uproot discrimination.
Thank you so much. Ms. Abrams, Mr. Hawkins said in his written testimony that the current conditions in terms of voting rights aren't so bad, that we've really done a great job, and it's not like 1965, and we're just doing wonderful, good things in essence. And the pre-clearance requirement is not necessary. In other words, he thinks the Supreme Court got it right in Shelby when it concluded that Congress exceeded its constitutional authority to impose pre-clearance requirements on certain states and localities. Yeah, there's federalism, but sometimes the states go too far and they interfere with federal statutes or federal constitutional privileges, and then the feds have to come in. What do you think about Mr. Hawkins' position that we don't need the pre-clearance requirement anymore?
I vehemently disagree. I grew up in Mississippi, I live in Georgia, and I recently went through a fairly public display of the need for pre-clearance. Mr. Kemp, the current governor, then Secretary of State, had been denied the ability to impose the exact match policy under pre-clearance. The moment Shelby was passed, he reinstituted this policy. In 2016, he had to enter into a federal settlement because 34,000 voters were denied the right to vote in an election cycle, in fact, over 2 election cycles. He agreed to the settlement in 2016, and the very next year ushered through a different iteration of the exact same discriminatory policy. And in 2018, a third court told him to stop it because, sorry, a second court, because 53,000 voters were suspended from being able to register to vote. That's a small kernel of an example. The state of Georgia has found itself in multiple lawsuits where upon adjudication, the state has been told that their actions were racially discriminatory. That means that people have been denied the right to vote. They will never be able to unring that bell. And I believe that preclearance, in fact, we know empirically that preclearance would have permitted more voters to cast their ballots because the policies that denied them the right to vote would not have been enacted.
Thank you. And I just have to say, because it's one of the things I think about a lot, you said you're from Mississippi, and I want to say some nice things about Nina Simone.
Thank you.
You're welcome. Mr. Johnson, you're recognized.